lie ahead and to keep us up to date in terms of where things are, where and when. So what we will do is, colleagues, we'll hand over to the AG. And I think let's start with Road Accident Fund, AG.
Recording in progress.
And then go to SAA, because as indicated, the SAA meeting, SAA related matters meeting is next week. So it is good for us to get a briefing from AG. So colleagues, blessed Wednesday to you all, and welcome to everybody in the meeting. And without any further ado, let me hand over then to Team Auditor-General, and then we will be in your hands. So we will do one presentation, full questions, and then the next, because I think the issues are so vastly different. Yeah, all right. Thank you very much. Team AG, over to you.
Morning, Chair, and morning to the committee members. I do hope you can see my proof of life. On the floor, it's Madidi Malosingo. I am a acting business unit leader for National B. National B is a business unit within the Auditor-General's office that looks after the transport portfolio, and in particular also looks at RAF. Maybe before we start, just to thank the committee and the chair for providing us this opportunity to brief you on the audit outcomes of RAF. Chair, with your permission, before I continue, I'd like to introduce some of the colleagues that are going to be with us in the session today. And let me start with Nicholas Mukwena. Nicholas is the acting deputy business unit leader, also in the transport portfolio within the Auditor-General's office. So he supports the teams that are operating in that sector. And then also with me is Vinay Rambali. Vinay is the senior manager on the engagement. I think if you look at it from a private sector perspective, he would then be the audit partner on the engagement. Also with me is Walter. Walter is joining us from our technical team, and he will assist us in terms of some of the technical questions that might come from the committee. And also, Chair, I will maybe just reference our colleagues that are also joining us from the SAA team. I just would like to acknowledge Tamsanga Zikode, who is the head of portfolio for the business unit that deals with SAA. Together with him is Zolisa Zwakala, who is a business unit leader in that division as well. And also Pumulani Rabonda, who is also from a business unit that is primarily dealing with SAA matters. Chair, maybe with that, we can go to the business of the day. Today, we're really here to brief the committee around the audit outcomes of REF. Particularly, we'll take the committee through this audit outcomes stemming from 27-18, but our primary focus is going to be on the 2021 audit outcomes. Chair, you would have noticed in our briefing document that if you look at the audit outcomes of RAF, when you look at it from 27-18 to currently the 2021 audit outcomes, you would see that there has been a general regression in this audit outcomes. If you look at some of the reasons that have led to the regression in outcomes, it primarily relates to a change in the accounting manner in which the REF had been accounting for the provision of claims, which are claims that arise from accidents that have happened in the REF environment, for which REF then becomes liable. So that change in accounting treatment, Chair, is one of the areas that has led to the regression in audit outcomes when we look at the quality of the financial statements that were provided for audit. In looking at that, Chair, we will then take you into our confidence in terms of the reasons that we find ourselves differing with the ref was accounting for these matters, and we'll take you through the process that we also followed in terms of ensuring that we properly ventilate these matters with management, with governance, and ultimately the other parties that got involved in trying to resolve the difference of opinion that existed between the Auditor-General's office as well as the Accident Fund. Also, looking at the regression in this audit outcomes, one of the other key areas that led to the regression was material non-compliance laws and regulations, specifically as it relates to the preparation of the financial statements in accordance with framework. And secondly, also when it comes to compliance relating to procurement and contract management precedents. So we will go through some of the findings that we have identified in that space and the materiality of those areas. Lastly, in looking at the audit outcomes, one of the other key things that we looked at which impacted the outcomes in the current year was the issue around the and the assumptions that were used, and that was also largely impacted by the change in accounting policy for how they've been accounted for the provisions in claims. So we also are confident in terms of how we have applied ourselves with regard to what was in the outcomes in that regard. Chair, in concluding this audit, I think it's also important to really reflect on the process that us as the Auditor-General followed during this audit. And this is another area that we believe that engage the committee around how we have tried on our side to make sure that we have provided sufficient opportunity to REF to present their case to us, and how we've to that in terms of the process that was followed. Ultimately, this protracted audit process that only ended in December. And in looking at the process that was followed, we'll then take into our confidence in terms of the dispute resolution process that REF then opted to follow. What was then the outcome of that? And obviously, we know that at the end, we concluded that the view that the Auditor-General had in terms of the provision of these claims was how we then concluded on the audit. And that to the REF then taking this matter through the courts with the litigation process that is currently and we'll also take into our confidence in terms of the two areas that the part A, we refer to it as part A, where we were interdicting our audit report, and secondly, the second part which relates of the difference in opinion and where we are with that process. Obviously, Chair, some of the matters the committee on today, we may not be fully ventilate because they are sitting in but we will try our level best to make sure that we take the committee into our confidence in as far as it relates to the process, and we'll try and also just make sure that we're able to provide comprehensively so that the committee understands where we are and how it's actually going. Chair, maybe with that, if I can maybe pause there with that introduction of our briefing on the outcomes, I'd like to hand over to Vinay Ram then through the detail, and hopefully the context that I've provided at the beginning will assist the members in comprehending the remainder of the detailed feedback that will be coming through. So with that, Chair, maybe if I can pause there and allow Vinay, with your permission, to then take. Thank you.
Okay, thank you very much for that introduction. We are completely in your hands, so you'll structure the briefing as you deem fit for effective output on your side. Thank you very much.
Good morning, Honorable Chair, honorable members of the committee, colleagues from the Auditor-General and other attendees. I'm Vinay Rambali, just proof of life. I will switch off my video now, Chair, while I'm presenting. If I can ask, please, for permission to be able to share my screen so that I can take you through the presentation. Thank you, Chair.
BK?
Yes, Chair, let me get on that.
Chair, I'm hoping you are able to see my screen and the presentation.
Good to go.
Thank you very much. Once again, good morning, Chair. Good morning, honorable members of the committee. As Mari indicated, we will be taking you through the briefing on the Road Accident Fund audit outcomes of 2021 financial year. And briefly, in terms of the presentation and the content of the presentation, we will touch on the audit opinion history, the overview of the audit outcomes in terms of a general message, the litigation process that Madi mentioned, and then specifically going into the details of the contents of the audit report in terms of the specific modification paragraphs, the areas of focus being the compliance subject matters, as well as the auditor performance information, and then touching on the drivers of the internal control that led to the regression, and overall conclusion, and then some key recommendations that we would like to make to the committee. So in terms of the presentation, I'm moving on to page 3, which covers basically the purpose of this document is basically to give the committee an overview of the audit outcome and the matters that led to the regression. On the organizational structure, Chair, what you will see is this is the latest organizational structure that we have of the Road Accident Fund. Obviously, this does change based on when posts are filled and changes to the organizational structure. If I move to page 4, Chair, on the top, the funding, the RAF is primarily funded from the fuel levies. And in the 2021 financial year, they've received 42 billion rands. So the fuel levies is based on the consumption of fuel by the road users, and that gets paid to the Road Accident Fund. In terms of the audit opinion history, you'll note from 2017-18 to 2018-19, it was an unqualified audit opinion. The key areas that led to the fact that they didn't get a clean audit in 2017-18 was around procurement and contract management, certain non-compliance identified there, the failure to prevent expenditure, fruitless and wasteful, as well as irregular expenditure, and there were certain issues around their reported performance. In the 2018-19 financial year, the key issue there was the reliability of the reported performance. And in 2019-20, they've in fact got a clean audit, so there were no issues that we've identified. And then 2021 was a disclaimer of audit opinion. And the disclaimer of audit opinion was primarily driven by the change in accounting policy and how they accounted for the claims liability. So you'll note the areas of modification being claims expenditure, claims liability, the non-disclosure of all of the irregular expenditure, the fact that they haven't given us written representations from the accounting authority, and then there were certain disclosure notes that were incomplete when assessed against the accounting standards. And then there were issues around compliance with legislation, the quality of the financial statements, basically the material misstatements that we've identified, the failure to prevent irregular expenditure, and there was an issue around procurement and contract management that led to the non-compliance and the incurrence of irregular expenditure. We didn't have any findings on the usefulness or reliability of their reported performance. So in summary, that's the audit opinion history. So in terms of the next page, which is page 5, covering the overall message, Mari did touch on the regression from the previous year. And the regression was primarily driven by the change in accounting policy. So what RAF did in 2020-21 financial year, management decided to change the accounting policy for accounting for the claims liabilities. And they've used the IPSAS 42, which is the International Public Sector Accounting Standards that was released by that body to formulate the accounting policy. And when we assessed that change in accounting policy, we found that it was in conflict with the generally recognized accounting practice, or GRAP, that is normally, which is applicable to the road accident fund. And the key difference that we picked up, Chairperson, was that the timing of recognizing the liability under IPSAS 42 was significantly different when compared to the conceptual framework within GRAP. So that trigger for the liability would have been under the conceptual framework, and our understanding of the RAF Act would have been when an accident occurs, then there's immediately a liability that should be recognized by the RAF. However, when management adopted IPSAS 42, they've assessed that they've only incur a liability when an offer has been made to a claimant and not before then. So before then, there is no liability. According to management. Furthermore, IPSAS 42 is not in the list of standards that's available for use in Directive 5. And Directive 5 is prescribed, or the standards that are set for GRAP is determined by the Accounting Standards Board, which is the authority to determine the appropriate accounting standards. And where there isn't an applicable standard under GRAP, the GRAP Financial Reporting Framework, then what the ASB would do is they would then issue options in terms of Directive 5 of additional or alternative standards that could be used. And in the past, the RAF used IFRS 4, and that was a standard that was available for use in terms of Directive 5. So just based on the impact of the change in accounting policy, Chairperson, you'd be able to see from 2018-19 to 2019-20, what RAF was recording as a liability for their claims was around 330 billion for 2019-20 and 272 billion for 2018-19. And that was driven by the liability that they recorded for outstanding claims. So those would have been claims that are registered on the RAF system. However, certain processes still needed to be completed before a final offer could be made. And also claims for accidents that were incurred but not yet reported. So an accident would have occurred, and ultimately what would happen is that there would be a liability on the RAF for that accident. These amounts, Chairperson, is determined by an actuarial expert, and that has been done in the prior years. So preceding 2021 financial year, an actuarial expert would have determined those amounts. And then in addition to that, you would have had claims that were through the system. So it's been approved for payment, however, not paid at year end. And that's the 15 billion in 2019-20 and the 11 billion in 2018-19. However, if we go to 2021 financial year, you'll note that based on the change in accounting policy, RAF then didn't recognize any liabilities for the claims that are registered on their system. That still has to go through a process. They haven't recognized any claims for accidents that have incurred but not yet reported to them. And the only liabilities that they have recorded was for the claims requested, not yet paid, and for claims for which they have made an offer but not yet requested for payment. So 27 billion in 2020-21 financial year compared to 330 billion in the previous financial year. So the significant impact has been that the reduction in the claims liability of the change in accounting policy. So if we move to page 6, that just unpacks further the fact that we concluded that this misstatement was pervasive. It affected the material account balances and classes of transactions on the financial statements. So to the user, we felt that the user wouldn't be able to appreciate the true extent of the liability of the RAF due to this change in accounting policy. So that was our significant disagreement. What management then did is then they followed a dispute resolution process, which is allowed, and they have approached the Office of the Accountant General, which is the authority that deals with accounting matters. And this process of the dispute resolution was protracted, and it ultimately led to a view that was expressed by the OAG on the 4th of December. However, the RAF did not agree or accept that process or the views of the OAG. And as the Auditor General, we had no legal basis to continue delaying the finalization of the audit. Hence, we undertook to finalize the audit, and we've issued our audit report on the 21st of December. So in assessing the appropriateness of using IPSAS 42, we concluded that that resulted in a material misstatement to the financial statements, and the financial statements were pervasively misstated, which led to the disclaimer of audit opinion. The next area in terms of the overall message, Chairperson, was on the irregular expenditure. Management did identify an additional 92 million rands of irregular expenditure, and that was basically on one award where the price evaluation was not done in terms of the Preferential Procurement Policy Framework Act, or PPFA. The matter was investigated, and the consequence management has been undertaken or is in the process of being undertaken by management on that. And the key root cause for that was the preventative controls over compliance monitoring was, in our view, ineffective. That led to the incurrence of the irregular expenditure. If we move to the next area in terms of the overall message, the going concern, and Chairperson, you'll note that RAF has in the past has continually been in a net deficit and a net liability position. And with this change in accounting policy, the true extent of the net liability position was not evident due to the huge reduction from 330 billion to 27 billions of liability on the claims side. However, even without that, they were still in a current liability and net liability position, and that poses certain solvency issues and liquidity challenges for the RAF, and our uncertainty as to whether the entity would be able to meet its obligations in the foreseeable future. And taking that into account, and we assessed whether there was adequate disclosure in the financial statements around this uncertainty and what management's plans were to mitigate against this uncertainty. And we found that that disclosure was insufficient. And based on that, we've included an additional modification paragraph due to the limitation of disclosure around the management's plans. Then on the representation letter, Chairperson, as part of the audit process, we do annually request written representations from the accounting authority to confirm that they have fulfilled their responsibilities in terms of the preparation and the presentation of the financial statements in accordance with the applicable financial reporting framework, which in this case is a GRAP, and that they've provided all of the information to us and that they have recorded all of their transactions completely in the financial statements. We were not provided with that written representation, and that was a part of audit evidence that we weren't able to obtain on the audit. So hence we concluded an additional disclaimer of audit opinion paragraph in the audit report. Then in terms of the audit finalization, Marty did touch on this a little bit, where the process was delayed and protracted, and that was purely as a result of the disagreement by management on the conclusion reached by us as the Auditor-General on the appropriateness of using IPSAS 42 to change its accounting policy. We did start our engagements immediately after receipt of the financial statements, and that process was protracted and then referred to the Accountant General as part of the dispute resolution process in August 2021. The dispute resolution process, Chair, did take quite some time. And as I indicated, the OAG did give their views on the 4th of December. However, RAF management disagreed with that. And then we didn't have any basis, or there wasn't any process that we were aware of that could continue to delay the sign-off. And hence we signed off the audit report on the 21st of December. In trying to set up or in trying to conclude the audit in December, we did request certain engagements to happen. Normally the engagements with the audit committee, and for them, for the RAF to provide us with the adjusted financial statements, because there were certain misstatements that were identified, for instance, on the claims expenditure, as well as the irregular expenditure identified for management, and also the written representations, which I did speak to earlier. And these were not set up in a timely manner. Hence, we concluded the audit in the absence of that. And as I indicated, the audit report was issued on the 21st of December. We did issue a courtesy letter to the executive authority on their responsibility to table the audit report that was issued on the 21st of December. And failing which, we would then proceed to publish the audit report by 31st of March 2022. So in the absence of the executive authority tabling the audit report as part of the annual report, we then concluded and published our audit report submitted to the Speaker of Parliament on the 31st of March 2022 in accordance with the Public Audit Act and the PFMA. So that's in terms of the process that was followed in terms of finalizing the audit. The next area that we covered, Chairperson, on page 8 is around the litigation by the RAF against the Auditor-General. This litigation was, or the notice of motion was served to us on the 15th of January, and it was in two parts. Mari did touch on this, the first part being one which wanted to interdict us from publishing the audit report that was finalized, and secondly, to review the disclaimer of audit opinion and the content of the audit report. So basically, part B was around to make sure or to try and declare the audit report and the contents thereof invalid and unlawful. So in addition to that, the declaration of invalidity was for a period of 6 months. So they wanted 6 months to try and remedy that defect in terms of the audit opinion and the content of the audit report. RAF then filed a supplementary affidavit on the 5th of April 2022, and there were 14 grounds of review in that application, which basically touches on or questions the process that we followed as the Auditor-General to finalize the audit. It questioned our overreaching of powers in terms of determining appropriateness of accounting policies, and questions the basis that for the conclusions that we reached in determining that it was inappropriate for RAF to use IPSIS 42 and the conclusion and classification of RAF activities. We were successful as the Auditor-General in opposing Part A, and this, however, RAF did file a leave to appeal that ruling on Part A. It was heard on the 21st of April 2022, a Chairperson, but the judgment was reserved. And then we are in the process of busy drafting our replying or answering affidavit to Part B, and we don't have a date yet when that will be set down for hearing in the High Court. So that's in terms of the overall message. In terms of the specific modification paragraphs or disclaimer paragraphs from the audit report, this is per the audit report, Chairperson. And you'll note that it was a disclaimer of audit opinion, which means that we couldn't express an opinion on whether the claims liability and the claims expenditure and the supporting disclosure notes were correct or fairly presented. And there was a limitation placed on us because the amount, as I indicated, that is used, or the amount that for the provision for the outstanding liabilities is normally done by an actuarial expert. In the absence of that, we couldn't confirm whether those amounts in the financial statements are fairly presented or not. And this was due to the disagreement around the using of IPSIS 42 to change the accounting policy. The other disclaimer of audit opinion paragraphs included in the audit report was the change in accounting policy. and the fact that it wasn't disclosed adequately in terms of GRAP 3 on the accounting policies, estimates, and errors, and the impact of the prior years. So it only reflected the impact of the prior years and not the impact on the current year due to the change in accounting policy. Further to that, there was an additional disclaimer of audit opinion paragraph on going concern. Chairperson, as I alluded to earlier, the full extent of the liability is not included in the financial statements. Hence, the financial position of the RAF is not fairly presented, and also management's plans as to how they're going to mitigate that risk of not being a going concern was not sufficiently disclosed in the financial statements. Then on claims expenditure, there were certain misstatements through the audit process that we've identified, which were not corrected by management. And Chairperson, this was done on a sample basis. Our testing is normally done on a sample basis. So the misstatements that we've identified did impact the current year and the prior year. And we weren't able to conclude that claims expenditure was then fairly presented. On the irregular expenditure, Chairperson, the additional irregular expenditure of 90 million that was identified by management wasn't corrected in the financial statements because we used the financial statements submitted at 31 May to conclude our audit, as management didn't give us updated or revised financial statements when we are concluding the audit process. Then further to that, an additional disclaimer of audit opinion paragraph was around the written representations. And these were the representations that we needed from the accounting authority to confirm that they have fulfilled their obligations around financial reporting and the fair presentation of the financial statements. Then if we move to page 11 on the key focus areas, predetermined objectives of performance reporting, Chairperson, as I indicated, we didn't identify any material findings around the usefulness or reliability of outcome 1 that was selected and scoped in for the audit. On compliance, the irregular expenditure that was incurred by RAF over the 3 years, it's been around 340 million, a slight increase from the prior year of 3 million, but remember that the 90 million is not included in the 344 million. So in essence, we're looking at about a 93 million increase in irregular expenditure. Management does take action when they do identify irregular expenditure, and the 90 million was, as I said, due to the non-compliance with the triple PFA in the price evaluation. The bulk of the irregular expenditure of 335 million was identified in the 2017-18 financial year, but related to a contract that was awarded much earlier, Chairperson. And that matter is currently being investigated by the SIU. In terms of the other findings on the compliance subject matters, we did speak about the quality of the financial statements. So due to the adoption or the use of IPSAS 42, we found that the financial statements were not fairly presented. And in terms of the root cause or the internal control deficiency, we found that the accounting authority did not put adequate measures to make sure that they do prepare the financial statements in accordance with the applicable financial reporting framework, which is GRAP in this case. And then we make certain recommendations that they should be looking at enhancing their preventative controls to make sure that they are preparing their financial statements in accordance with the applicable financial reporting framework. And then the audit committee should also provide some oversight over that. In terms of expenditure management, the steps taken to prevent irregular expenditure, I did speak about the 90 million, Chair, the irregular expenditure that was identified by management. And this was due to ineffective preventative controls over compliance monitoring. And here we're recommending that they should enhance their system of internal controls to make sure that they try and prevent these instances of non-compliance that lead to irregular expenditure. Under 6.3 on the IT performance, there were certain weaknesses that we've identified in the IT audit space. And recently, in the 21-22 financial year, the RAF IT network was a victim of a malware attack. And those were as a result of certain of the weaknesses that we would have identified in prior years. So this impact of the malware attack as I said, was in the 21-22 financial year, and we will assess that impact in the current year audit, Chairperson. In terms of the drivers of internal control, we assess the drivers under three key broad areas: leadership, financial performance management, and governance. And you'll note that we have a concern, or rather an intervention that is required around oversight, responsibility, reporting, and compliance. And that is mainly due to the change in accounting policies. So what we're saying is that management supported by the accounting authority should ensure that they apply appropriate oversight when these key decisions are made around the changes to the accounting policy that impact the financial statements generally. And then if I move further down, the compliance with laws and regulations, again, the ineffective preventative controls that led to the irregular expenditure, record keeping, especially in procurement and contract management, to make sure that information is available when requested, and then governance in terms of enhancing their oversight, and then internal audit in terms of reviewing the financial statements thoroughly before they submit for audit purposes. And then in terms of audit overall conclusion, Chairperson, on page 14, I mean, the disagreement over the accounting treatment of the claims liability is the main reason for the regression in audit outcome. It has led to or affected the relationship between the RAF and the Auditor-General, and has diverted our attention somewhat towards addressing other audit-related matters. We have engaged RAF management in the accounting authority with a view to rebuilding that relationship and avoiding similar challenges in future. And as the Auditor-General, we believe that the courts are not the suitable platform to resolve these technical complex accounting and auditing disputes. In terms of recommendations to the committee, Chairperson, these are some of the suggestions that we want to make, is basically to follow up with the executive authority on the actions that are being taken to address audit findings, enhancing oversight on the RAF, and following up with the RAF accounting authority on the permanent appointment of key executive vacancies, such as the Chief Operating Officer, Chief Internal Audit, Chief Strategy Officer, etc. And then the action plan that is drafted to address the audit findings. And then engage the executive authority on the actions to be taken to make sure that we don't experience similar challenges as per the current year. Chairperson, that's where I'll stop, and thank you for the opportunity.
Okay, thank you very much for that briefing by the AG on the RAF. I just want to say one thing, colleagues. There is a litigation before court, and Scope has been cited as a respondent. We are going to be scheduling a briefing by Parliament Legal Services. It's a class action. It's got no adverse implication on the committee, nor is it just cites us as a respondent on that. So there will be briefing on it, and it's RAF related. So it's just that I just want to bring that to the attention of colleagues, right? Babu Somya, you are first off the bat, and colleagues, please indicate if you wish to speak. Babu Somya, over to you.
No, thank you very much, Honorable Chair, and good morning, the colleagues and the Auditor-General team, which is here. In the first instance, I wanted to establish, Chair, because in the materiality of things here, sharply, a matter which has been raised, which comes up, is as a result of a standard which come from the EPSIS 42, which is not in the list, and the issuance of any standards in terms of the custodianship resides with the Office of the Accountant General. The AG engages on the audit function based on the existing standards, and therefore any policy permissions which deals with such matters as accounting treatment would have to arise out of a formal authenticated accounting standard by the accounting general. I don't know whether we have here from Treasury someone who comes from that office, because the materiality aspect rise from that fact. If you hear all the aspects that relate to the AG's finding, they hang on that area for the completeness of our engagement with the AG on this matter. Can we hear from Treasury? Because my question is of the view that AG does not necessarily develop any standards, follows the set standards, prescribed standards, you see from Treasury. And so the confirmation of the report as it has been handed to us currently. Thank you, Chair.
Okay, Bab Somya, thank you very much. No, National Treasury is not here today. It's just AG this morning who are presenting on the audit outcomes. We will get National Treasury to be part and parcel of the hearing of the meeting, and then flag your issues for that day, for the 17th. So, Sis Dombi, Ben, please just make it a point. Ordinarily, they will be in attendance in any case as they attend all hearings, but just make sure that they are there on the 17th. Right, Honorable Hadeb and Honorable Liz, and then Honorable Mente in that order, please.
No, thanks, Chair. I just want to first get clarity from the AG team. I know this question might be better explained by the entity, but if they've got information, they would assist as to were they given the reasons that led to the entity changing from the previous accounting standard to this ABSIS 42. What were the reasons given? And secondly, Chair, is it entirely up to the entity to change? Shouldn't they get concurrence or confirmation, given the fact that there was mentioned that the current ABSIS 42 is not included in the list of standard for use in Directive 5. If they can also explain what does Directive 5 entail. The second question, you mentioned that the management did not agree with the feedback from the Office of the Accountant General. What was the feedback? You did not give us exactly what was the feedback. The last question from my side, Chair, there was an indication that AG was successful in court on Part A, and there were no indication, just a brief indication what was Part A all about, Chair, and Part B. So if it's not issues that are sub judice, just give us a sense and understanding in relation to these issues, Chair. That will be my clarity-seeking questions for now.
Thank you very much, Honorable Liz.
Thank you, Mr. Chairman, and thank you to the AG. Mr. Chairman, the RAF has been bankrupt for many, many years. and nothing changes, and yet we now get into a legal dispute about the extent of the bankruptcy. It's quite ludicrous. What can the AG give us some indication of what their legal costs have been to defend this ridiculous action by the RAF? What we have is the RAF keeping the courts busy, pushing costs, taking taxpayers' money and wasting it on court action, instead of focusing on their core function. So what exactly what's the costs of the AG, legal costs so far? And we'll ask the RAF in due course what their costs have been. As per Honourable Khatebe with an H, can the AG give us some indication of what exactly the RAF hope to achieve? Because no matter how you look at the liabilities, the organisation is bankrupt, and what exactly would be the benefit in the long run, other than simply changing some figures on a bankrupt balance sheet? Then I must say, Mr. Chairman, I'm somewhat disappointed in the temerity of the recommendations by the AG. I would have thought that the recommendation.
Injani?
Sorry, Honorable, solve your mic. Sizozindaba esingazifuni.
Hayi mhlawumbe sizothanda ukuze. Mr. Chairman, I would have thought that the AG would be a lot more robust with its recommendations. So if the AG perhaps has some other thoughts about recommendations for the committee, I would appreciate that. Thank you very much.
Thanks, Honourable Liz. Honourable Mente, and then AG will come in to respond, and then if there's, then we will move on to SAA. All right, Honourable Mente.
Thank you, Chair. I hope my network is clearer today. You can hear me?
Yeah, we can hear you perfectly.
Thank you very much. Chairperson, I also have and concur with the sentiments of Ubeki, Honorable Adeb. And then 2019, they had clean audit. 2020, there's a disclaimer. There's something fundamentally wrong. And I'm not sure if I'm the only one who is not understanding this. And AG ought to at least explain what were the red flags when they were there. Because if they were clean 2019-20, and all of a sudden 2020-21, they change the standard, the auditing standards and the policies or whatsoever. And no one see it coming, and no one had picked this up. Wasn't there any sign that things are going to change? And wasn't there any indication to the Auditor-General in terms of the standards that they are going to change? Because for me, there is something fundamentally wrong, and I'm not sure who was supposed to pick it up at what point. And it's correct, Babu Somyo, when he says, between Auditor-General, National Treasury, there is an explanation that must happen here. Because, Chair, if ever you are confident and comfortable with an entity for this year, there are questions, and I'm sure there is a kind of a question template they utilize to understand what standards are they using, how do they get things right. And then the very same prescript on that particular template changes, and no one has indicated that we are changing, so that they become aware, and they also make the other entity aware that that which you want to bring in and utilize as your auditing standard is not acceptable, and therefore is going to give you problems in the certain areas, whereas AG, we cannot then be able to obtain the necessary information we require in order for us to make findings on your day-to-day that you are dealing with, where financial standards are concerned. So I am not clear at all. I'm hearing what is being explained, but I'm just not clear that an entity can just penduka in a year's time with no one picking up, no one knows what's happening, and then only on auditing you pick up everything else, and then it lands you on the red. We know the status of this entity and its financial problems and everything else. But when it comes to auditing, there ought to be some kind of a relationship, and that relationship is the one that must be informing the Auditor-General, the National Treasury, and the entity of our relationship is have this kind of an understanding at this level. But the moment you then jump to this level, it means that me and you, we don't understand each other, and therefore we don't use the same tool to measure each other. Thank you, Chair.
Thank you very much, Honorable Mente. Yeah, it's a total, it's an interesting case. It's a total 180 from one extreme end to the very extreme end, from clean to. Just on that, my only question is, and then AG, please come in. Was there a change in the team, that the AG team that was auditing REF from the previous year to the year under review, in terms of persons? All right, AG, over to you.
Thank you. Thank you, honorable members and Chair for. I'm going to kick us off in terms of some of the responses, and my colleagues will then also come in. I think in terms of the first question relating to the use of IPSIS 42 and the pronouncements by National Treasury, I think for us to clarify that the accounting standard setting body is the Accounting Standards Board. And when we conduct our audit, we conduct our audit in terms of standards that have been set by the Accounting Standards Board. To the extent that the National Treasury was involved in this case, it was really to assist us with the dispute process, as Vinay has articulated earlier. If you go to the question specifically that the member had raised around the materiality aspect of the standards, I think that National Treasury would need to respond to, but as you would have seen, as the numbers were being presented in terms of the audit outcome, IPSIS 42, all the decision by adopt this particular standard did have a material impact on the financial statements of RAF and how they account for the provisions claims. So I think, in summary, from our perspective, we really audit in terms of what has been made available. And I suppose it gets me to the next question, which was asked by Honorable Hadebe around the use of Directive 5. So leading or coming from standards that would have been set by the Accounting Standards Board, Directive 5 then would then assist us in terms of the Accounting Standards Board, those standards that are available for use. And case, IPSIS 42 was definitely one of those standards that was then not available for use. So that is just the in terms of the use of Directive 5. I think also to answer the Honorable Hadewa's question in terms of whether management is within their rights to set a change in accounting policy. So the simple answer is yes. Management and those charged with governance through the accounting authority of setting out the accounting policies that will be used for adoption in the financial statements and determining the fair presentation of the financial statements. However, in this case, what we Auditor-General is that in the process of adopting this policy, what happened was that the accounting authority adopted a standard which was not available for use. So once the set by the Accounting Standards Board, the accounting authority to prepare the financial statements in terms of that accounting framework. And in this instance, as they were making the decision to formulate the accounting policies, they chose through a standard which was not available for use as in Directive 5. In terms of the Part A, so if we look at so what we were what to do was to interdict the Office of the Auditor-General from issuing the audit report, and as indicated, the AGSA was then successful in Part A, and hence our decision to proceed to finalize the audit report and also to Parliament having no other reason to withhold. In terms of Part B, that will generally deal with the merits of the case in terms of the contents of our audit report, and that is currently underway. We are in the process of responding to the affidavit that has been sent to us by REF. I think on the questions of the legal cost, I'm going to defer that to our tech. Looking at some of the recommendations, I think the one key thing that we realized through this process is that it is important that the necessary oversight be exercised over the REF affairs, particularly in terms of the going concern matters that continue to plague the institution. That as we look into the issues that may seem to be, but it is also important that the committee then starts looking at the action plans that have been put in place by the accounting authority in terms of remedying the particular situation and other matters that we've highlighted as being of concern. And I think we've spoken quite a lot about the going concern. We've spoken a lot about the compliance matters that we've raised, and particularly also the accounting treatment of REF. So I think from that perspective, we do believe that more oversight needs to be executed, and particularly around those audit matters. If we look at the question that was raised around the clean audit versus the disclaimer, I think what is clear is that in the current financial year where we're discussing the audit outcome, had not been made in terms of changing the accounting policy. So when we looked at the 1920, we were fairly comfortable that the REF was actually taking or accounting for the provisions claim in terms of the standard. And when we got into the new financial year and the changes started being discussed, that is also quite proactive in terms of ensuring that we did engage management, leading to the preparation of to ensure that in terms of what this change would mean for the REF would have then been found. And when one looks at the accounts of REF, really, it looks like it's chalk and cheese when you compare the, but at the core of was that change in accounting policy. Looking at the change team, so the team that audited the 2020-21 financial statements the same as the one previous years. Only in the current year, in 2022, do we have some change in the team. The team that have done this audit in previous years remains intact. The changes have only been at leadership level, with Nicholas joining the team. Maybe I can pause the chair and allow my also come in and respond. Thank you.
Okay, thank you very much.
Okay, good morning, honorable members. I hope you can hear me. Okay, all right, I hope you can. So the question around legal fees, obviously when there's part A and a part B, what happens in the court in part A is that the court will say that obviously as it pertains to costs, that matter is reserved until the finalization of part B. However, obviously, we do get invoice, for instance, on a monthly basis by our legal team. And at this stage, the estimated amount that we've paid, because obviously we were in court for part A, which can be an expensive exercise. At the moment, the estimate is 500,000 rand. So that's the amount that we can do.
Walter Bamba, you have got an echo in your space. I don't know whether it's another mic on, but there's a feedback. So we are battling to capture all that you are saying. So can we all just mute colleagues, and then Walter Mhlampe, please just start again. So I'm not sure colleagues captured you because your voice was duplicating. Everything you said was coming in twice. It was like one of those radio feedbacks. Okay, please just start again so that we can capture correctly what you say.
Thank you very much, Honorable Chairperson. I hope it's a bit clearer now. So just to reiterate what I said obviously when it comes to a review matter where there's a part A and a part B, what ordinarily happens as it pertains to costs is that the court in part A will say that any matter pertaining to costs is reserved until the finalization of part B. So and obviously the cost will follow the team that would have won the case, and then obviously the losing would then be the one to pay the costs incurred. But there's a rough estimate, because we do get invoiced on a monthly basis. The rough estimate at this stage on the costs, primarily because we were in court for almost half a day, is the estimate at the moment is 500,000 rands. Thank you, Chair.
Okay, thank you very much. Are there any further responses, and are there any other follow-ups on the REF matter, and then we can move on?
Honorable Chair, it's Vinay. Just to deal with. Thank you. Just to deal with the question around the reasons why RAF decided to change their accounting policy. The reasons that were provided by management was to ensure that they achieve fair presentation. Hence the use of Ipsos 42, and that was the reason given to us. And then the other question, I think, around the OAG and what their views was, I think they concluded that it was also inappropriate for RAF to use Ipsos 42 to account for the claims liability. I think we've covered all the questions here. Thank you.
Chair.
Vinay, you fading? I don't know what happened. You sort of was just drifting. Honorable Mente?
No, Chair, there's just one clarity I need.
Okay.
Did the AG only become aware of this Ipsos on their arrival at the entity for audit? Wasn't there any red flag on any indication that they are changing their accounting standards? The standards which are going to put the AG on a back foot in order to obtain the required information for them to meet the requirements of auditing the entity. Because this is going to be very serious. I think AG looks at it from a point of, no, we didn't get it, that's it. And we're just going to give them a disclaimer. And they're going to stand firm to say, we used international standards and we see nothing wrong with that. We met our obligations. And if you, AG, cannot then be able to obtain your information, it's none of our business. That's the kind of detail we need. I'm not sure, Chair, if I'm clear, because I'm really not comfortable with these explanations. I'm not hearing the explanation of AG. We're dealing with this entity, we're going to call them and they are going to say, we met our obligation, we complied with the particular standards that we utilized as an entity. So for Auditor-General to say they don't find it, we don't understand. Can we now be clarified, completely clear? You don't know the standard, you don't recognize the standard, you were not aware of the standard, and when did you become aware of it? Thank you, Chair.
Hadebe, Chair. Hadebe.
All right, Honorable Hadebe.
No, thanks, Chair. The follow-up is that having received a clean audit, they decide to change to another accounting standard. And the explanation is that they want to get fair representation. Was clean audit not giving them the fair representation that they want to achieve with the change? I know this question is entirely dependent on those that made the change, which is the entity itself. But if the AG team does not have further information, it's okay. But if they do, it will assist us in interacting with the AG, with the entity. What's this fair representation that they couldn't get when they achieved a clean audit? What I also don't understand, Chair, are there any consequences for the entity to choose Ipsos 42, which is not part of the list as per the Directive 5? Shouldn't there be consequences for such? And why is this international public sector accounting standards, which I assume if something is an international standard, it incorporates all the standards within various accounting practice. Why is it not part of the directive? What are the reasons for excluding Ipsos 42 from the list of standard for use in Directive 5, so that we have that understanding, Chair? But I'm more interested in the consequences for an entity to willingly and knowingly opt for something that is not catered for in Directive 5. If they can share with us, will we be justified to seek to recommend that there should be consequences for such an action? Thank you, Chair.
Babu Samuel, I see your hand. Is it a current hand or a historic hand? All right, let's get responses to that. And Babu Swami, I think that's a historic hand. All right.
Yeah, it's a legacy hand.
Legacy hand, all right. All right, let's get responses to that then. Thanks, colleagues.
Okay. Thank you so much, Chairperson, for the questions. I'm Mukwana Nicholas, part of the Auditor-General team. I'll start with the question that was raised by Honorable Mentor around the changes. What has changed? Whether, as AJ say, we have seen the red flags. I'll explain to this. I'll respond to it in this way. We have been having engagement with RF management on the change in accounting policy, around June. And as part of the preparation of financial statement, management is allowed to change accounting policy, but that has to be done in accordance with the prescribed reporting framework. And as AGSA, our responsibility is to come and evaluate the appropriateness of that change in accounting policy. Then after management have made decision to change these accounting policies, we came and say we engage management and indicate that we don't believe that change is appropriate. It's in line with the appropriate framework. Then, of course, management disagreed with our positions, and we also did not agree with their positions. And in terms of the standard, where there is a disagreement, we are allowed to conclude on a disagreement. And this position that we're at now, where we have issued a disclaimer of opinion because of that disagreement. There has been engagement with management about the matter, but it's just because we are not finding each other on the matter, hence the conclusion that we've issued now. Then the question that was raised by Honorable Hadebe around the clean, if there was a clean audit in the prior, was that not a fair presentation? It is our position. It is our position as AGSA that in the priors, those financial statements were fairly presented. Hence, we were able to issue an modified opinion. And in the current year, we have the view that the financial statements are not fairly presented. Hence, we are able to. Hence, we issued a disclaimer of opinion. Around what was the reason for exclusion of IPSAS 42 from Directive 5? It's made because ASB they are still trying to find an appropriate standard for the entities like your RAF. Then like they have indicated in their correspondence that they are still in that project. Hence, they currently like they don't have IPSAS 42, or they're not prescribing IPSAS 42 for use. I think those are my response, Chairperson. I'm not sure if there's anything I missed. Thank you so much.
All right. Thank you very much. All right, colleagues, let's do this.
Chair, the question, who then supposed to effect consequence on the choice of opting for something that is not provided for in the directives? Which a body that ought to follow up in this on this matter?
Okay. Right. AG. Messingo.
Yes. This is Nicholas. Yeah, I can to respond to that.
Okay.
Yeah.
Mantolash, stand by.
Chair, thank you very much. My apologies to come in here. Maybe I did not hear. I've got problems with the network. I just want to hear whether the system that was used by the entity is acceptable according to the accounting procedures. Just to hear, maybe it was responded to, but I did not hear. Is it acceptable according to the South African accounting procedures? Just as additional question, please, Chair. Thank you.
Okay, thank you very much. AG team, you will respond as you deem fit in terms of delegating who responds.
Thank you, Chairperson, and thank you, Chairperson, and thank you to the members for the additional clarification questions. So maybe let's start with just maybe clarifying the role of the AGSA and the role of the Accounting Standards Board and the role of management. So as we've indicated in our engagements today, so the Accounting Standard Board, which is a body that is entrusted with the responsibility of setting out the accounting framework, is the one that would set out and a framework that must be adopted by a particular entity. Obviously, then the responsibility of the accounting authorities then to ensure that they prepare financial statements in accordance with the framework that has been promulgated by the Accounting Standards Board. Where we find ourselves with in terms of the REF situation is that us as auditors will obviously audit in terms of the accounting framework that is available for use. And in this instance, as Nicholas has indicated, the IPSAS 42 was an international standard that was not yet recognized by the Accounting Standard Board as one that can be incorporated into the accounting framework that can be adopted by entities in preparing their financial statements. So hence to that end, when we were auditing in terms of as Auditor-General, we then could not recognize the standard that had been adopted by management in terms of formulating the accounting policy and ultimately reporting on the accounting affairs of REF for the 2021 financial year. So I think that clarification is important to say, yes, the standard is available. Yes, there is an international standard, but it had not been actually recognized by the Accounting Standards Board as one that can actually be used by entities in terms of determining the accounting for matters such as provisions for claims within entities such as RAF. So that's the one part of it. So there's a question that was also asked around consequence management. And as we've indicated, the accounting authority is the one that is responsible for the preparation of this financial statement. To the extent that when we audit this financial statement, we find that as Auditor-General, those financial statements have then not been fairly presented in accordance with a particular framework. Our responsibility is really to then express an opinion on that, and that is what is going to then be included in the financial statements. In our audit report. But to the extent of consequence management in terms of whether there is any particular regulatory body that would be tasked with taking consequence management in terms of an accounting standard that had been adopted, which is not available for use. We are not aware of one, but safe to say that there is always a responsibilities on those charged with governance, on the executive authority, and other parliamentary structures to interrogate the results that are coming out or the outcomes that are coming out, and certainly engage the REF in terms of those audit outcomes and understand what was their reasoning for opting for what they've indicated, and ultimately through those engagements, then appropriate action can then be taken through those oversight structures to the extent that it has been interrogated, action plans have been interrogated to that extent. So I think from our responsibilities, Auditor-General, it's really to say that at the end of the day, we would then issue an opinion, and then it's up to the oversight structures to interrogate that further and take the necessary actions where appropriate. Chair, I think I've responded to the questions. If I've missed any, I'm more than willing to take another question if there's one that we've actually missed. Thanks, Chair.
Buya Slalo, Buya.
No, I'm trying to process that. Honorable Mente.
Yeah, Enkosi Sihlalo. Miss Singo, you are coming all right now. But where you are not going is the standard is not recognized by your system in order for you to have to conduct an audit. Did you make the entity aware that you are using an IPSAS standard that is international? Fine. However, in terms of our frameworks, available frameworks to us as Auditor-General, and for us to audit you as an entity of state, and us as an Auditor-General, with the responsibility of ensuring that you meet the standards of expenditure and whatever you get from a public purse. This which you are going to use is not recognized by us. Was that advice offered? And upon it being offered, was it rejected? At what stage? Because these are the questions that we must be clear of before the entity comes to us. Thank you, Chair.
Right, Honorable Bucas.
Thank you, Chair. Just on that, sorry, Chair, I want to ask, are there any engagement between the AG and RAF, except for the legal battle? Because through the legal battle, they will not be able to rebuild the relationship. So what is the current status now? Are they just waiting for the legal battle, or are there any engagement between them? Thank you, Chair.
Okay, AG.
No, thank you, Chair, again, and thank you to the members. I think the question the answer to the first question is yes, we did certainly engage RAF as soon as they made the decision to adopt IPSIS 42, or rather to change their accounting policy to align with IPSIS 42. So that engagement did indeed take place. We did advise them that the standard is not available for use. We also did advise them that it would not be appropriate to use that particular standard in the adoption of the accounting policy and the preparation of the financial statements. So yes, those engagements did indeed take place, and I think those were, again, if you've listened to what we've been engaging on throughout the morning, was that it was actually at the core of the disagreement and the protracted nature of this audit process in the current year. It was certainly around those engagements as soon as we became aware. In terms of the current status of our relationship with the RAF, I think we do acknowledge on both ends that the audit process of the prior year has actually been challenging. But what we also do acknowledge is that we need to continue to work together, certainly both from executing our mandate as the Auditor-General and from RAF needing to execute their mandate. So currently what we've agreed with management is that we will certainly continue with the audit process. We will work on rebuilding the relationship. Yes, there is a litigation process that's undergoing. And I think we make those resolutions together with management, understanding that that process will still unfold, but it should in no way prevent us from continuing with the audit process and ensuring that there is certainly accountability in terms of the REF accounts in as far as our mandate is concerned. Thank you, Chair.
Okay. I think because colleagues, REF is on the 17th, let us digest this. It's just that what comes out here is clean audit does not translate into service delivery. I think that's the difficult question that one grapples with on one hand, and then of course changes must be sanctioned in law and in statute. So we need to grapple with all those fundamental questions about REF, and as things stand now before us, AG has disclaimed them, and it is now incumbent on REF to explain itself. And I think we've got a clear basis. As Honorable Mentor said, the explanations are finally coming all right. So I think let us, we can bring to a close the REF matters. Mam Dolashe, is that a new hand or a historic hand? A legacy hand?
Chair, is a new hand.
Okay.
Just a small but cost. Just a small but cost for us as COPA. I listened the to's and from between the entity and AG. they are at the same level. I think as COPA, let's take it upon ourselves, Chair, to look at this matter more closer and find a way on how it can be resolved and be avoided going forward. Because the impression that is created here, there's non-cooperation to one of them when it deems fit and creating more problems for the other. So I think in avoiding this going forward, Chair, let's as COPA look at this matter so that we don't sit and ask questions between the two of them, but we provide more leadership than anything else. I'm worried, Chair, if one entity can behave like we are being informed, then we have got bigger problem than we anticipate. Thanks, Chair.
Okay, thank you very much, Mamti. All right, AG, let us go to SAA. Babusuma, please mute. Let's go to SAA.
Hello, Chair.
Oh yes,
Chair.
yeah. Okay.
What? Yeah. You see, my interview is a little one.
Okay.
The other difficulty which you find
So we're losing
currently is that the matters are in the courts, and what the AG is doing now is on the basis. It's only on the basis of the report, something which they have done. And what they gave us is what they ought to probably account on the areas of failure around RAF currently. And that's why earlier on, the Office of the Accountant General was very clear for us to determine the veracity of the absence of approved standards in terms of their own accounting. So if that is the case, into the invitation of RAF, we must expect, or we might probably find ourselves in a situation where they would see we are not currently
Babu Swami, we're losing
these matters. In our view, ourselves. Thank you very much, Chair.
Okay, Babu Swami, please send what you are saying in writing. We lost you there, but I think we can have a discussion about it. All right, Honorable Hatib, I see your hand, and then we'll go
Chair,
on to SAA.
Yes, my question when I ask about Part B, Chair, I wanted to ascertain what is sub judice and what's not in terms of us engaging with the entity on the scheduled date, Chair. I assume by mere fact that having one Part A to release the report, there's nothing that will prohibit us from engaging on the content of that report unless Part B seeks to Chair, in a way, dismiss some of the findings as contained in that report. But being a layman, as I am, my initial sense was that once the report is released, we can engage on it. But I'm cautious and mindful of the fact that there's Part B that is still outstanding. So the essence of my question is to find out what is it that is still sub judice and cannot be discussed.
Okay, it's fine. We will look at that. Honorable Mentor will be the last one on this, and then we move on, colleagues. Honorable Mentor.
Thank you, Chair. Just one area of concern also is that did the AG write to the accounting authority as well as the executive authority of RAF pertaining to the difficulty and the unrecognizable standards the entity was using, even when they are advised not to continue using that, and what was the response? Thank you.
Okay. Responses to that?
Thank you, Chair. Chair, am I audible? Okay,
yes,
perfect.
you are.
So, Chair, thank you again. Maybe to the questions that have been raised in terms of whether, as the Auditor-General, we did engage the accounting authority. I think the question is the answer to that question is also certainly yes. I think at the point when we started the engagements, we were engaging with management, we were engaging with the audit committee, and we did seek the assistance of the accounting authority as well in terms of assisting us in terms of resolving the difference of opinion that we had. Also in those engagements, we were quite clear in our message around the appropriateness of the accounting policy that had been adopted, and the resulting consequences of fair presentation to the financial statements. So the simple answer to that question, Chair, is that yes, indeed, we did engage the accounting authority. We also did sensitize the executive authority when it came to us finalizing the audit process and proceeding to table the audit report. You would see it in our briefing document that was also an avenue that we also considered, and the executive authority did also respond to indicate to us that this matter was sitting in the courts, and hence REF was not able to table the audit report at that particular point in time. But as indicated, we did then proceed to engage the Speaker of Parliament and table the reports accordingly. I think on the matter of that was raised in terms of what matters could be sub judice, maybe let me hand that over to my technical team to just assist with that. Thanks.
Yeah, thank you very much, and through you, Honourable Chair. So definitely, with regards to this particular matter, the court documents are of public record, so nothing is sub judice in that regard. The report has since been published and is now a public record. Therefore, yet again, nothing in that regard is sub judice.
Walter, please just repeat that response.
So as it relates to
moved to it rather fast, and I think it's at the heart of what Honorable Hadebe was gauging.
No, thank you very much, Honourable Chair. So as it relates to the aspect of sub judice, to the extent that are there certain aspects that cannot be engaged upon as it relates to this matter, my response to that is no, there is nothing, because one, the court papers and all the arguments that have been raised by both parties are now a matter of public record because they have been made public through the court process. Secondly, as it relates to the actual contents of the report, because Part A wanted to interdict the publishing of the actual report, but obviously the court disagreed. Therefore, we went ahead and published the report via the Speaker of Parliament. Therefore, the contents of that particular report are also a matter of public record. So nothing in that respect is sub judice, Chair. Thank you.
Okay. All right. Thank you very much, AG. All right. Let's go to SAA.
Yes, morning, Chair and committee members. My name is Elisa Swagala. I've been introduced earlier by Madi. With me to talk to SAA is Fumulani Rabonda. He will talk us through the presentation we've prepared for the committee chair. I think if we could start with beaming the presentation already. But as a bit of background on SAA, I think this has been an entity in transition, Chair, and an entity going through a lot of changes in the past 3 years, at least. We know that in December of 2019, it went into business rescue at the trigger of the board. It emerged from that process last year around end of April. So insofar as the audit process is concerned, then Chair, we audited SAA for the first time for the 16-17 financial year. And post that, when we were just about to complete the 17-18 audit, then we had to pull away through the request of the board as they were trying to sort the liquidity and solvency challenges that were overwhelming at that stage. So that audit was then paused in 2019. And we just concluded that audit earlier this year. I'll call it 2 months ago in Feb. That was the 17-18 audit. So what we're going to talk to, Chair, is a bit dated by regular standards, but we still owe you those insights as a committee and as an audit office. And then we'll catch you up also on the outstanding audits. We do not have the financial statements for at least 4 years if we count March of 2022. Those financial statements are due by the end of May. If those are not submitted by end of this month, then we'll have 4 years in outstanding financial statements from SAA to enable us to kickstart the audits. But we'll take you into a bit more detail, Chair, as we go through the presentation. And my colleague Fumalani will drive us through those. Thanks, Chair. Through you over to Fumalani now.
Okay, thank you very much. He asked for sharing, right? I don't think he needs those. Thanks, Solisa, right? So, Fumalani, you're good to go.
Good morning, Honorable Chair. Good morning to the honorable members of the committee, my colleagues from the Auditor-General of South Africa, and also other guests who may be attending today's session. Zolisa has already introduced the message for today, and which majority of it is sitting on this slide that I'm doing currently, Chair. But just to try and close it, some of the key elements here. So SAA did come out of business rescue on the 30th of April last year, as it's public knowledge. And since then, we then resumed with our public responsibility to complete the outstanding audit, which was the audit of 2017-2018. That process, we started the process with management and the board to get them to approve the financial statements and send out the financial statements for auditing, and we completed that process by February this year. We then also, during the process, we're also busy on the background trying to come together with an approach that will help us to kickstart the audits for the outstanding financial years 18-19, 19-20, 2021, 2022. And there's something that we just need to also highlight, Honorable Chair, that the ongoing process of transferring the 51% controlling stake from government to a consortium led by Takatso Consortium does change a lot of things. And it's some of the things that as we are coming up together with the process of closing the outstanding financial statements, we also need to be mindful of, and it's a process. It's also important that the role of Parliament gets affected by that, the role of the AG, and also the role of government in that. Because what will come out of that is that SAA in its own form will not necessarily be what we call a 100% a state controlled entity. Majority of it will be private control, which means that government through the National Treasury, they need to, and through the National Treasury and the Department of Public Enterprises, then to determine a model that says how do we oversee this entity, because it's no longer going to be a public entity per se as per the PFMA. The requirements of the PFMA that apply publicly may not necessarily apply to them. When we engage with the Department of Public Enterprise, they did indicate that the model that they are going to adopt is similar to the model of, also the nature of the entity will be similar to what they have with Telkom, where the government has a minority stake there, and Telkom does not require, it's not required to, it's not accountable in a manner that PFMA requires. So that's what's going to come out of here. And as we're engaging, we also need to think about the impact of this particular thing on the role of various stakeholders that oversee the audit or the entity SAA. Trying to, yeah. So this is just a timeline of the key events, Honorable Chair. We have already spoken to some of these ones here. And I just want to talk to the last one, which I was talking to now. On the 3rd of March, government, through the cabinet statement, they did announce that the agreement to sell 51% controlling stake to Tagato Consortium has been signed. What was outstanding, which is still outstanding now, are the regulatory approvals. And those approvals talk to the approvals from the Competition Commission and the other aviation authorities that needs to approve the transferring of ownership. And as I did indicate that the impact of that changes the who owns the entity and the nature of the entity and things like those. When we engage with the DPE, maybe let me start by saying that we have not seen the agreement. We did request the agreement, but the DPE did indicate that because the agreement is not finalized in the transaction, and finalized in the terms of, in sense of approvals that are needed, they will only be making this agreement available to us once that transaction has been finalized. So there are some questions that we've just highlighted, which will be answered once we have looked at the agreement to be able to see the role of government in the entity, how do we then place ourselves there as the public sector auditor, and also understanding the role of the parliamentary oversight bodies, including yourselves. We also understand that the one subsidiary, being Mango, is not included in the transaction. So what Tagato is going to buy is SAA and other subsidiaries with Mango removed from that particular transaction. That is why currently through the business rescue process, Mango is currently published in invitation for interest for parties that are willing to buy the controlling stake in Mango, so that Mango can be a separate entity and also have its own strategic equity partner. Another key thing as we are busy dealing with this period of transition is the question of accountability and consequence management, because there have been these 4 years which we highlight that they are outstanding, which SAA has been a state-owned entity, 100% controlled state-owned entity. And if public funds were utilized in that period. And we need to ensure that there is accountability for that. There is also management for the wrongdoing that may have happened there. So it is very important that from our side as the Auditor-General and also other oversight bodies, in this transition period, the manner in which we deal with the concept of consequence management, it still ensures that those irregularities that may have happened when SAA was still a state 100% controlled state entity, they are still being dealt with even when SAA is in private hands. So basically, you'll understand that at the AGSA, with our expanded mandate of dealing with material irregularities, we have also included SAA. On the outstanding audits, our approach will include material irregularities, but how we deal with those material irregularities must be appreciative of the fact that when SAA is no longer government controlled, PFMA may not necessarily apply. There will be no requirement to disclose irregular expenditure. There will be no requirement to disclose fraud expenditure. And as a result, there will be no requirement to investigate and deal with those type of expenditures, because those requirements come from the PFMA and there are requirements upon the accounting authorities of public entities, which will not be the case with SAA. So how we then deal with these approaches of consequence management, we must make sure that our findings and the type of recommend that we put there, they are informed in a manner that they still drive and enforce accountability even when SAA is in private hands. So this is what they were trying to highlight in this particular slide when we are highlighting the element of material irregularities, and also trying to highlight also that the report from State Capture Commission, the very first volume, had a chapter specifically on SAA. We did take note of that. We did look at the irregularities that were highlighted there, and those are some of the things that during the transition, we need to make sure that they are not lost, and nobody does anything about them. They must still be highlighted through these approaches that we're working on. So, Chair, now we move to the audit outcome for the period ended 31 March 2018. This is the part which my colleagues also did indicate that in the normal sense of things, it's kind of late. And this is because of that suspending the audit and only us finalizing the audit now in February 2022. But we still have the responsibility to share this message with yourself, Chair. In that we started auditing SAA. We took back the audit of SAA in the period 2016-2017. In that audit, we gave the group a qualified audit opinion. All the entities within the group were qualified. And then we audited again in the 2018. And that year, the results were stagnant in qualified, with only Mango regressing to a disclaimer. And the reason for the disclaimer is primarily because at the time of studying the report, there was insufficient evidence to support the going concern assumption of Mango. And that has now been supported also with the Mango going under business rescue as well, to say there is that an inability for an opinion to say, is this company a going concern company or not? We have already started with engagement with management and the board at SAA, and also with the DPE to formulating our plan to kickstart the outstanding audits. And the primary of that, in that plan, is the commitment from SAA on the timelines on when are they going to be able to submit the financial statements for all the remaining years, and also for each and every company within the group, because most of those subsidiaries, they are what we call major subsidiaries in the group, which means that if one of them is not submitted, they affect materially the financial result that are sitting in the group financial statements. Hence, we need the financial statements for all of them. This slide, Honorable Chair, is showing the areas of qualification. You can see that we had 12 qualification paragraphs, starting with the qualification on property, plant, and equipment. Specifically, it's an accounting requirement around the regular review of useful lives and residual values, which we concluded that the manner in which it was done, it was inadequate. There were qualifications on the completeness of irregular expenditure. We'll show you a slide on irregular expenditure, and also on fruitless and wasteful expenditure, which was it's incomplete. Which was disclosed. We had limitation of scopes on trade and other payables, inventory, maintenance costs, and also intangible assets. We concluded that the values, that the valuation of trade and other receivables was incorrectly done, which resulted in an understatement of the receivables. There were also limited scope on tax and deferred tax, related parties as well. And also we concluded that there were inadequate impairment assessments that were done on the investment in subsidiaries. So the money, the investment that the SAA have made in their subsidiaries, we felt that the valuation there may not be correct because the impairment assessment was inadequate. And finally, we also had the limited scope on the commitments that were disclosed. Around compliance, we also had about 10 material non-compliance, and the areas related to financial statements, two of which is that there was late submission of financial statements, linking directly to the fact that the board could not give us financial statements that were approved back in 2019 when we suspended the audit, and that only came now. So that's a late submission. The financial statements, because of the material misstatement that we identified, were also not complied with the financial with the requirements of the PFMA. There were our audits of the assets also identified that there was no inadequate controls to safeguard and maintain the assets. So hence we had the material non-compliant in that regard. And also there was a financial assistance that was given to subsidiaries, one of which was, I think it was Airchefs, which the manner in which that financial assistance was given did not comply with the Companies Act, specifically the requirement for a shareholders resolution to support that financial assistance. That's the non-compliance that we reported back in 2017, 2018. and also quarterly reports which were not submitted on a regular basis to the shareholder department or to the executive authority as required by the PFMA. Because of the linking with the qualification on irregular expenditure and fraudulent expenditure, we reported material non-compliance on ineffective steps to prevent this type of expenditures. And there were findings under a number of findings basically under procurement contract management, which are grouped under the term uncompetitive and unfair procurement processes. And also we were not convinced or didn't have evidence to support consequence management. Hence, we said that there was inadequate consequence management. So that is the audit that comes out of it. And then just continue on that part, Chair, or specifically on the aspect of irregular expenditure and fraudulent expenditure over the 2-year period that we audited. You will see that in 2016-17, the financial statements of SAA, they disclosed an irregular expenditure of 126 million. When we did the audit the following year, there was a lot of irregularity that was identified that related to the previous years. That's why there was then an adjustment of that 16-17 irregular expenditure by about 11.9 billion. So the irregular expenditure then that was incurred in the 2016-17 financial year, as represented by the grey bar, was over 12.1 billion. In the year of 17-18, an additional 9.9 billion rand was also incurred in irregular expenditure, and bringing the total irregular expenditure balance, closing balance as of today, to 22 billion rand. That is the balance that is disclosed. However, as we indicated earlier on, this balance, we qualified on it on the basis of incompleteness. So that it means it's not complete, as management has not yet fully undertaken the process to quantify the full extent of the irregular expenditure. So that this figure that we're sharing now must be taken in that context. Then the fraudulent expenditure, which is the expenditure that is incurred in vain. So basically, there was no value for money for this expenditure. In the 16-17, it was 40 million rand that we identified it and was disclosed. And then in the 17-18, it was 130 million rand. However, Chair, we need to highlight that, again, this expenditure which is disclosed is incomplete. That is why we've got the qualification paragraph around that. And the closing balance, which is incomplete, 24.8 million rand. We also highlight that in the disclosure, there are 2 areas which the disclosure make. So first is that about 130 million rand has been written off as irrecoverable. And also there is 12.9 million rand that was removed as recovered. So the 130 million rand, we were able to get the information to say, indeed, this was irrecoverable. It related to penalties and interest charged by SARS back in the day. And when investigation was done by management, the conclusion was that there was a system error that caused the under-provision of the VAT that was declared to SARS. And the SARS, as a result of that under-provision, charged penalties and interest, but they could not identify that this, the investment could not say this particular person or role player was to blame or is liable. Hence, they could conclude that that particular amount is irrecoverable, and they wrote it off in accordance with the irregular expenditure frameworks of National Treasury. But the 12.9 million rand, which is disclosed in the financial statements as recovered, that is part of the qualification, and that balance we could not get enough evidence to support it. So we could not verify that 12.9 million rand that indeed it was recovered as part of the qualification. So, Chair, in concluding our message around SAA, we just want to also highlight the key root causes that are behind this audit outcome for the financial year ended 31 March 2018, and also the recommendations that we highlight when we engage with management around this thing. It's issues around instability and vacancies in key positions. Back then, we know that there was multiple changes in executive positions at SAA, which affected the control environment and the stability of the controls in the environment. management was struggling to also implement adequate controls to prevent non-compliance with procurement legislation. They could not effectively develop and monitor implementation of a remedial audit plan to improve the audit outcome, which were reported in 2017. There was also inadequate basic financial management disciplines. This mostly relate to issues of reconciliation and also ensuring that transactions are supported by documents and that those documents are available for audit on a timely manner. And the financial statements themselves, as indicated by the qualification, it was demonstrated that they were not adequately reviewed to ensure that they are reliable set of financial records. So with this message, we also say now that as again, in linking with the transition period and management trying to put together the financial statements for the other financial years that are outstanding, we highlight the fact that a lot has changed in the entity. We're not talking about the same control environment that was there back then. We're not talking about the same size of the entity that was back then. There are changes in the board, there's changes all around, even the operations of SAA. And also there's still going to be changes with the transition that is underway of the strategic equity partner. And we're therefore saying that the board of SAA, together with management, should assess this outcome and determine the areas of concern in the context of the current circumstances to ensure that an effective action plan is developed to address these root causes. The root causes are still relevant, but they need to look at them in the context of the current circumstances of the entity, the size of the entity and the operations. And they must make sure that that action plan is implemented in preparing the financial plan for the outstanding financial years ranging from 2018-19 up until 2021-2022. We also talk about a realistic nature of this action plan. What we have seen that with entities, Honorable Chair, that they put together action plans, but when we look at the action plans, they become very unrealistic in terms of appreciating the depth of work that needs to be done to address the historical material misstatements and also the time that is needed to do that. So, Chair, thank you very much for the time. Let me pause here and give you back the platform. Thank you.
Okay. Thank you very much. Okay, colleagues, AG team, are you done in your entirety on this one? All right, colleagues, Babu Sono, I'm going to assume that's a new hand, and then Honorable Lise in that order, please. Okay, Honorable Lise.
Thank you, Mr. Chairman, and thank you to the AG. Mr. Chairman, we've known for a very, very long time about the sad state of affairs with SAA, and so probably very little is new here. But, Mr. Chairman, there's some questions that I'd like to put to the AG. First of all, there was a regression from the first year you audited and to the second, and you say it was because you had difficulty accepting the assertion that Mango was.
Colleagues, can you please mute your mics unless you're on the platform?
Thanks, Mr. Chairman. You had difficulty in accepting the assertion, which I assume that the board made, that Mango was a going concern, and that resulted in the regression from the 1 year to the next year. Having said that, what we don't see in recent years, we used to get, probably about 5 years ago, we used to get financial statements for all the component companies of SA Group. What we're seeing now is the consolidated, you've given us a report on the consolidation, and we still haven't seen the financial statements for the individual components. But you're telling us that at that stage, Mango was not a going concern, and consequently, of course, it's now gone into business rescue. but I suspect the reasons it's gone into business rescue are not necessarily because it's not a going concern. I suspect that there are other reasons tied up with the Takatsu consortium. Mr. Chairman, so the first question would be, in this year under discussion, did the AG accept that the SAA group was a going concern? And there'll be follow-up questions depending on the answer. What then I'm led to, Mr. Chairman, is the next point, is AG has informed us that they have not been allowed to see the agreement which apparently has been entered into between the government, the Department of Public Enterprises, I assume, and the Takatsu consortium. And yet, Mr. Chairman, there is extensive comment about the status of SAA in terms of this agreement, including that the agreement doesn't include mango and others. So on what basis, AG, are you making these comments if you haven't seen the agreement? I must say, Mr. Chairman, I find it astounding that the AG has accepted that they be precluded from seeing this agreement. I find that incredible and a great disappointment about the AG, and perhaps the AG can give us sort of legal reasons why they should not see this agreement, and yet they comment fairly extensively to us as a committee about that agreement. It's now nearly a year since that agreement was announced, and we see no real progress. We hear that it's been signed. We hear that National Treasury were not happy with certain aspects, and yet the Auditor-General seems quite comfortable to let it simply take its course. Mr. Chairman, if I may, there will be some follow-up questions depending on the answers that I get. So if I may just hold there.
Okay. Are there any? All right. Seems as if
Yes, Chair. Now, I just want the AG to assist us and make the implicit explicit, Chair. As soon as we now know that there's an agreement that was signed, even though the AG has not seen this agreement. But there are implications in relation to our mandate as SCOPA and oversight in terms of how do we deal with the entity moving forward, including the outstanding issues. I would request the AG to be explicit that moving forward, if this were to be, the agreement has been signed, if they were to see this agreement by tomorrow, what is it that will no longer be done by us in terms of PFMA and our mandate? What outstanding matters can we still continue to pursue? They've tried to explain in their presentation, but they were not that crystal clear. So that, Chair, when we engage with the executive authority, the accounting authority, we know exactly areas where we still have work to do and areas that will automatically fall outside our mandate. I need that guidance from the Auditor-General so that we are not seen Chair as acting outside our scope and our mandate once this signed agreement is seen. So what now made us to be where we are today dealing with this matter? Is it only because the agreement has not been seen? Once it's seen, we are no longer including this entity as fully owned by government? I'm trying to get a clarity check. Can I be assisted in that regard? We know that it was in 30th of April 2021 when SAA exited the business rescue. We still have, I think, about how many? 1, 2, 3, 4 outstanding. Can we still pursue those, even though it will be forming the likes of Telkom? Who will be accountable in ensuring that all the outstanding audit are concluded if it will be 51% owned privately? Thank you, Chair. Let me pause there for now. I hope my question has been captured clearly.
Okay, thank you very much, Honorable Deb. All right, I see no other hand. All right, let's get responses to those first two, and then we'll come back for a second round if need be. AG?
Okay.
Thanks, Chair.
Yeah.
All right, I'll start, Chair, and my colleague Fumalani will also step in. I think the first question from Honorable Lee centered around whether SAA was a going concern, and there was a link to Mango there. It was during our presentation represented that Mango was disclaimed because of going concern challenges. So, Chair, at the end when we signed 1718, and again we had the benefit of time by the time we signed. So the standards require for us at the time that we sign to look forward at least 12 months into the future as auditors and see, will this, are there any uncertainties, first of all, that this entity is facing in terms of liquidity and solvency? If so, what are the initiatives that the entity is putting in place to counter those? So, Chair, and I want to draw attention to note 50 and 51 of the financial statements of SAA. So they went to town there, Chair, in terms of painting the picture, and in note 51 of their going concern status. So from note 50, they talk about the business rescue, how all the aircraft leases were actually cancelled. They talk about their VSP program that was introduced, various headcounts reduced via the Section 189 process. They established a receivership. They received some money from government as part of the business rescue process. So all of those factors, Chairperson, then put into a bucket, and then you evaluate in terms of the way going forward. And then in note 51, Chair, so they outline their going concern status and analysis. They were outlining, amongst others, that they commenced flying within the domestic and the regional markets. They were talking to the SEP that had been identified and was at an advanced stage at that. They were talking to SAT and ESHEVs receiving funding respectively in order to restructure their businesses, and a whole lot of other initiatives, Chair. And what we did then as auditors, put that information all in a bucket and highlighted to the user those uncertainties and what the entity then says that they will do to counter those uncertainties, which all of us agree that they are still there in the horizon. And Chairperson, in our respect and in line with our responsibilities, then we drew an emphasis of matter in our audit report to draw attention to exactly that, to say there are still uncertainties around SAA's going concern status. However, this is what they are saying to counter those, the initiatives they want to put in place to counter some of those challenges and uncertainties there, Chairperson. So I draw attention to our audit report in that respect. And then in terms of Mango, Chair, the going concern has been raised there as well. We know that COVID impacted the airline industry maybe like no other because there was no flying for a period of time. Mango was no different. When we know that the business rescue then was triggered by the board themselves, noting and noticing the state that the airline, the low-cost carrier, was in. And again, Chair, we are looking at a benefit of time here at the time that we are signing the reports. By the time we're signing the reports, Mango was already in business rescue. And some of these matters were quite grave to assess, and in terms of how is Mango actually going to emerge, out of some of these financial difficulties. So those are some of the factors that influence the going concern status, Chair, both at SAA and Mango that's been mentioned. I'll leave the question around the PFMA from Honorable Khatebe to Fumlani. However, let me mention around the agreement. So, Chair, it's not a matter of we are comfortable that we haven't received the agreement. However, it's something that, as we've said, we don't have the Fs themselves, let alone agreements. We don't have the Fs post 1718. So it's part of the engagements that we're saying are still unfolding in us requesting and getting the Fs and everything else that accompanies the special transactions that are at SAA. So we hope in due time, Chair, we will get to that. There's no reason that we shouldn't get that agreement. And also, I guess, if the committee is interested to see and look at it earlier, DPE can also maybe step in and assist the committee. But there's been no barring, as far as I know, to say, AG, you shall not have a look at this agreement. So it's part of the ongoing processes and engagement. So I'll step there and my colleague will cover the other bits, Chair. Thanks.
Yep, that's fine. Let's get the covering of the other bits.
Thank you, Honorable Chair, and thank you, Zolisa, for those other responses. Chair, I'm getting bad network. Just to indication if I'm audible.
Yes, you are.
Thank you very much. So I think just starting with the question from Honorable Hadewe around the PFMA, Chair. It's for the period that SAA was what we call a state-owned entity or a public entity, they still need to be accountability for those funds and assets of government, because it was an asset of government. So therefore, for all the financial years up to the date when there will be legal transfer of control, there need to be financial statements that are of a public institution or an organ of state and must be audited appropriately, and the Parliament still have a role to oversee that. That is around the entity controlled by the state. However, we still need to remember that even post the transfer of the 51% controlling stake, there's still a government investment of 49%. That's still a government asset which still need to be overseen, and that oversight will happen in the context of the arrangement that are going to be in place between government as the shareholder through DPE or whatever mechanism that they put in place, and the other shareholders of the entity as well. So basically, it's not a matter of now that control is in private hands, we wash our hands, all of us in the public space, we do nothing. No, there's still a big portion which is an asset of the state in the company that we still need to be looked at. But we can't right now at this point put the detailed terms of this, the nature of the asset, this how we must oversee it, and the role of the AG, the role of Parliament, and all those things until the transaction is finalized. Then we'll be able to know the nitty-gritties around this particular transaction. Honorable is mentioned that they used to get the financial statements for all the subsidiaries as well. I think from our side, our role is around sharing the audited CAM, Chair, and I think SAA or the department may be requested to share the financial statements themselves together with the respective audit reports. We did issue audit reports individually to each entity, and the Zero Authority does have the responsibility to table those in Parliament. Honorable Chair, I hope we have covered all the questions that were raised. Thank you.
All right, I see the Honorable List has got his hand up. Honorable List.
I'm now Honorable, not Mazamban. Eh? It's,
the two are interchangeable.
Okay, Mr. Chairman, thank you. So, AG, you you have the benefit of hindsight, and I understand how that all works. But had you done the audit on time, so in other words, by September 2018, was it? A long time ago, because your basis of accepting the going concern assertion is events that have taken place subsequent to business rescue in December 2019, and the basis of an unseen agreement about a gifting of 51% of the shares to Takatsu. So had you done the financial or the annual audit on time, you would not have had the benefit of that future information. And I assume you would have then not accepted that the SAA group was a going concern. I would think that it would be pretty unprofessional had you done so. Given that that's the case, let's assume that's the case. My question really to you is, the directors who continued to allow SAA to trade for a further 3 years, surely they were trading recklessly. What would your opinion of that be?
All right, no, thanks, Chair. I'll start again, and my colleagues will come. Yeah, so Honorable Lisa, I think put it well to say, look, you when you sign a bit late, you do have the benefit of time. Had we signed SAA back in 2018, I suspect the opinion might have been different to now, because we know that in December of 2019, the board did press the button and entered the entity into business rescue, because the liquidity and the solvency equations were not making sense at that stage. So, and you fast forward to now, 2022, a lot has happened. Some people have expressed interest in the entity and made commitments in writing, binding agreements at that. Then it does change the picture a bit. And to Honorable Lisa's point, I think for us as auditors, we didn't give that a tick, if you will, because I'm still emphasizing in my report that use of the audit report, pay attention. There's some uncertainties around going concern at SAA, and this is what the board says will be done and what is unfolding. So at least we're not silent there. We were quite vigilant to not let that go, despite everything else that was happening. And then there's a question around the director's chair. Yes, we know when it comes to SOEs, both the PFMA and the Companies Act do apply. And in this respect, we do rely on other partners and other stakeholders, entities like CIPC as an example, who monitor, these entities, or must monitor these entities, issue a certificate if they believe there's reckless trading. I know for some of them, they've been issued Denel as an example to say, we observing that there might be reckless trading, tell us why you do not believe there's some reckless trading, So we observe all of those, Chairperson, and then the directors may be able to answer to say maybe they're doing the best under the circumstances, they're not trading recklessly, and also outline whatever else that may be at play, that maybe outsiders may be privy to, observing from the outside. So it is a complicated question, Chair, but I do appreciate the question from the member linking, the happenings back to the directors and what may need to happen there. For Malani, through you, Chair, may also come in if maybe there's one or two matters he wants to cast insight into. Thanks, Chair.
Through you, Chair, I just want to confirm that Zolisa did cover me. Thank you.
Okay. Colleagues, the SAA headache, of course, has been with us for the longest of time and has proven to be yeah, it's just one of those headaches, actually. So I think, colleagues, AG has given us an update of where things are.
Chair?
Yebo.
No, sorry, I ended up lowering my hand, and excuse my ignorance in this regard.
Okay.
So all the outstanding audits will still have to be finalized, and we are obliged to exercise our mandate in this regard to get those. Will the new shareholders be the ones that will be responsible for this in terms of accounting authority? How is it going to pan out, Chair? And please excuse my ignorance. I just seek the indulgence in us moving forward with the new arrangement of the SAA.
No, there's no ignorance there, Honorable Hattab. I think it's pertinent.
Yes, because as things stands, we know that the board of SAA are the ones that will have to come and account before us, and they are an accounting authority. So what will happen? I'm not sure. I'm just trying to get a clear matching line of the way forward in relation to us getting these outstanding audits. Thank you, Chair.
Right, no, thanks. I suspect the agreement is pertinent in this regard. And I think we need a focused attention on that because it provides, or rather should provide, for the roadmap and the kind of due diligence that was done to arrive at a position to dispose of 51% in the absence of almost 4 years of audit outcomes. So I think that is a critical element that we have to look at, and that's why I was saying that SAA is financial management matters are proving to be a headache, but I think we must exercise the continued patience of in progress, or rather progress with a particular patience as we peel an onion, because these are uncharted waters for all of us. So I think let us get AG to come in at this point just to provide a clarity in terms of what is outstanding, what happens to those. AG?
Thanks, Chair. I think to answer the question of the honourable member, then we've got 3 years, at least 3 years outstanding in terms of financial statements that SAA owes us as auditors. So once we receive those 3 years, and you can make it 4 years once we add 2022, we are going to audit those, Chair, as normal. We are going to table the audit reports and escalate to the portfolio committee, to SCOPA as invited, those outcomes as per usual. So we give that commitment on our side, because for those years and predominant for 2022, it might be a fraction of the year. SAA was still an SOE, a state-owned entity for that matter. I think for the period beyond that, Chair, we were engaging DPE as well to say, DPE, what role will you need from us as auditors now that government will have a 49%? So those details and nitty-gritties are not yet fully ironed out, Chair, and I suspect by DPE themselves to say the kind of oversight they will want over that 49%. In terms of assurance from the audit office, what kind of work or assurance they may still need from us. So those are still ongoing, Chair, and I think the question of the member there is quite relevant. So we'll unpack those as we go, Chair. But for the 4 years, we'll still bring those audit outcomes to Parliament. Thanks.
Okay, Honorable Hadebe, are you fine with that?
No, Chair, yes, I'm covered. Thank you so much, Chairperson.
Okay. All right. Now, let me therefore take this opportunity to thank AG for the briefing on the Road Accident Fund and SAA this morning. I think both very difficult briefings as they speak to a certain degree and evolution in the auditing space and insofar as parliamentary oversight is concerned. Both headaches in their own rights in terms of the new dynamics that they present. But I think we are equal to the task at hand, colleagues, and we will have the hearings as scheduled. So I think we can thank the AG very much for the presentation this morning. We will communicate, colleagues, when the draft report on ESCOM will reach you following our oversight visit. So because that is scheduled for the 11th of May, so that we can dispense with that report and have it sent to the House. Of course, largely to speak to, because it's a continued or rather a follow-up oversight visit from 2019, and the basis upon which 23 recommendations were made by us, and only 9 so far have been met. And well, of course, there's little wonder that things are as they are. We are in load shedding again. So we will do that follow-up report from ESCOM. So I'm hopeful that, colleagues, it will reach you by Friday or during the course of the weekend when it's done, so that you can be able to make your input, and hopefully we will actually adopt it next week on the 11th. So that's just the only matters before us. Unless there's any other matter that, colleagues, you have, there is nothing else on our side.
No, Chair, we're looking forward to adopting the ESCOM report next week, Tuesday.
All right. All right, colleagues, thank you very much. There's a question session this afternoon, so I'd imagine the House sitting is at 1500 hours. Have yourselves a wonderful day and a wonderful afternoon. Do take care. And on that note, Team AG, thank you very much. The meeting stands adjourned.
Thank you, Chair.
Thank you, Chair. Cheers, everyone. Bye.
Bye.